Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Cases that should have gone to the Supreme Court of Canada, but didn't. Jason McCartney was charged in a stabbing that led to a murder. And in the course of his trial, he argued self-defense as the basis of the stabbing and argued that he shouldn't be guilty of second-degree murder because he was acting in self-defense. That defense was rejected and he was convicted at trial. In the course of his appeal, he argued that the Crown's address to the jury, essentially the Crown's closing argument, as well as the Crown's cross-examination were improper, and that the trial judge had an obligation to provide a curative instruction to the jury or to provide some other remedy for the Crown's improper or unlawful conduct. The Court of Appeal disagreed. He sought leave to appeal to the Supreme Court of Canada, who denied leave. Mr. McCartney's case raises very important issues, because anytime you have a jury trial, both sides get to make submissions to the jury, and both sides have to be particularly cautious of their behavior in court, including during direct and cross-examination, so as not to leave the jury with any type of impression that would otherwise be unlawful. Jurors, unlike judges in trials, don't have the same legal knowledge and training to know what types of questions are appropriate, to know whether to not give weight to answers given in response to certain types of questions, or to reduce the weight given to the answers elicited in response to those questions. And unlike judges, jurors don't necessarily hear and see all of the arguments related to objections to fully understand the state of the law around the admissibility or use to which certain answers elicited in cross-examination or statements made during closing argument can be put. This was an opportunity for the Supreme Court of Canada to get into something that they really have not spent a lot of time addressing, which is the conduct of prosecutors and defense counsel in the course of criminal trials and how that can influence the minds of juries. While we have seen extreme cases, it's very rare to see cases involving remedies for jury instructions and remedies for improper closing argument or cross-examination be considered by the Supreme Court of Canada. Typically, the remedy that is ordered is a new trial, or in certain circumstances, an acquittal might be entered. But in these circumstances, there is an opportunity for further remedies to be inquired into, and the Supreme Court of Canada had the opportunity here to address the full range of remedies that should come from this improper type of conduct. Ultimately, the Supreme Court of Canada will have to deal with another trial that may potentially be unfair before it has the chance to say the wide range of remedies that it believes is appropriate for improper closing argument or improper cross-examination in jury trials. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.